Things to keep in mind with any type of bankruptcy. Just like with mechanics liens, there are rules. So you have to pay attention to the paperwork you get. There's a timeline for everything. So if you haven't ever gone on this website before, PACER, the Public Access Court Electronic Reporting Service, will enable you to go and look to see in real time where somebody's bankruptcy is and what the paper filings have been. One of the biggest challenges for credit managers is they hear the word bankruptcy and they freak out. Don't freak out. First of all, confirm that it's true. If you're hearing a rumor that one of your customers filed bankruptcy, ask your salesman. Salesmen are the hairdresser of your life. They know everything. So if you call up your salesman and say, hey, our favorite customer just filed bankruptcy. That's what I heard. What do you know? And then they usually have no problem calling and going, what's going on over there? You can do the same thing. Depends on who has the better relationship. So find out what's happening there. Once you find out, yes, it's true, we filed bankruptcy. Okay, what's going on? You can't ask them to pay you. Once someone confirms they filed bankruptcy, all collection action stops. You have to let it go. You can't say, what happened to my check, you flaming deadbeat? Absolutely not. You have to let it drop. So what are your next steps? You can have a conversation with them. You just can't ask them for payment. Then you want to pay attention to what's going on with the courts. If it's a Chapter 11 reorg, you want to get on the creditors committee if possible. If you've never been on a creditors committee, and if you're just starting out in credit, trust me, you want to do this. You absolutely want to get on that. Usually it has the 5 largest creditors are on there. However, you can reach out to the trustee and petition to be on it. Send them a simple email or letter. Hey, I would like to be on this. Here's who we are, blah, blah, blah. And 9 times out of 10, they'll let you on. It's great learning experience and you'll never get better information, especially if you have something to bring to the table. If you had filed a lien and it's part of that bankruptcy, that gives you leverage in the bankruptcy. Because unless the company that filed bankruptcy owns that lien, that's still in play with the owner of that property. So that gives you that nice leverage out of there that you might be safe, or at least part of your money will be safe. You also want to be able to hear what's happening within that, bring stuff to the trustee, and keep tabs on it. So pay attention to all the filings, read them. When they say don't file a proof of claim, don't until they're ready. But if you have a deadline for filing proof of claim, do it. If there's a meeting of the creditors and you have the opportunity to go, absolutely go. You're going to want to hear what they say. The amount of things that you will see in small claims court makes it worth it. When you show up for that meeting of the creditors and they roll up in there with their kids with no shoes on, looking sad, really, you brought your kids to your bankruptcy hearing? That's just a pity grab. And the trustee saw it for what it was, but it's very uncomfortable. You see the bankruptee roll up in his F1 or 350 with his alligator boots and his Oakleys. Yeah, honey, you don't look very bankrupt. You need to roll up in here looking poor because I'm about to strip search you right now. You want to make sure that you're able to represent, hey, here are the questions I want to ask. Most trustees will let you ask up to 3 questions. Sometimes they'll tell you, hey, go get a debtor exam of your own. You've got like 50 questions. Sometimes the trustee is like, roll on, girl, let it go. You've got my list of questions. So always go prepared with questions. The first top 3 is what I want to ask, but if the trustee will let me, I'll ask them all day long because they have to answer you. They're not very nice about it when you start to get a little rough with some of the questions, but you want to keep up on all of the filings and what's happening in there. You also want to know what's happening with their liquidations or if they're continuing in business. Typically what I'd like to know if it's a reorg and I'm standing there and it's a meeting of the creditors, hey, where did the assets go? I specifically know I had 2 rail cars of lumber. Where did those rail cars go? Well, they're on the property. We opened them. So we needed those to keep our business going because we're reorg and it's debtor in possession. So we're going to need those. It's like, okay, but they're rail cars. I'd like to, and you got those in the last 21 days. I've petitioned to take those back. So I'm going to ask the trustee, can you please not have them sell any of my rail car lumber? You want to bring up, hey, you just got that rail car just rolled up there. They were consignment or whatever it was. They were on consignment. You want to ask questions that are poignant to your position. So what as a company is the most important for you to know? Having a lien puts you in a different class. If the company that went bankrupt owned the land, owned the project, that's their land, their building, it still gives you a priority in the bankruptcy. So there's the grade unsecured, which is usually trade creditors. Then there's secured creditors, which is usually banks, landholders, people with liens, UCC filings, any kind of legal documentation that way. So that puts you in a different class. If the project was owned by someone else and just someone who did the work filed bankruptcy that you're suing, then you still have that remedy over there to be able to go get. In a typical case where, let's say there's no lien in play, it's just a straight bankruptcy, it really depends on what the assets of the company are, how much they owe the bank and the secured creditors that come before you, and then what's left. Don't be fooled. The trustee is sort of your friend. They're like a frenemy. They get paid by how much they bring back into the bankruptcy, but that's how they get paid. So all of the professional services get paid before you. So debtor's attorney, creditor committee attorney, any accountants, trustee, everybody gets their slice off the top. Then there's the secured creditors get paid out of what was brought back into the bankruptcy. And then what's left is divvied up among the unsecured creditors. So on the unsecured creditors, if I'm owed 50 and there are 3 others that are owed 100,000 and there are some that are owed 15 or 20,000, it's prorated. You get X number of, maybe you're getting 50 cents on the dollar. If one person files on a project, there's usually a whole lot of us all fighting for that money. So is it a first in time, first in line kind of situation, or is it a mosh pit where I have to share with everybody?
Well, every state does it different. But the old montage, know what your state's law says and what the statutes say. Here in Louisiana, it is a hodgepodge. You've got general contractors and architects around the same level. Subcontractors come before you. You've got tax liens, which are at the very top. And then you've got within those particular groups of subcontractors, it is which files first. Okay. So it is an intermingling of many issues, and that was basically what we had to inform the court on, is 20 pages of how everyone's liens fits into this process and why we're on top.
Okay.
But many times you aren't. So you need to know what that means. Even though you're going through the foreclosure and seizure process, you may be helping the party ahead of you get paid, and there may be no dollars left for you. So before you get into pursuing that claim with an attorney, getting to court, know how much the claims are that are ahead of you in line, because you don't want to pay an attorney to go through this process, seize a property, and then you just paid the guy who filed before you and there's nothing for you to collect on.
If you are able to use your lien rights in a bankruptcy, whether that project is owned by the bankrupt party or outside of it, you've actually elevated yourself. You are now part of a secured class, which is always better than being with, the gen pop, back there with the unsecureds. They're the last people to get paid, and that's usually where trade creditors fall. There's 1-step and 2-step distribution. So 1 step is directly to contractors. 2-step is if I'm a distributor selling to another distributor. That puts a wrinkle of complication in there. So you want to make sure that you're able to secure what you can. A lot of times, 2-step distribution does not allow you to have lien rights.
This is just a small taste of a much larger class. You can take the full class for free at levelset.com. Join me.